But one of the things that they want is his X accounts, and Elon is saying they're not your X accounts. You cannot have them. They're X's X accounts. And so back off. X is the sole owner of the services being sold as part of the sale of Alex Jones. You can't do that. X Corp respectfully submits that the X accounts may not be sold, assigned, or otherwise transferred at all, including the ones personally owned by Jones, including Jones's X account. So Jones can keep his accounts, basically. Alex Jones fights for survival, and Elon Musk is coming in to support him, filing a new motion objecting to the sale or the transfer of any X accounts that they're trying to take away from Alex Jones. And so we've got these two Goliaths now joining forces. And here is what Elon and his team submitted in the Southern District of Texas. X is objecting. So as we know the backstory here, Alex Jones, InfoWars, has had a court say he doesn't have any assets anymore and is now taking them away. But one of the things that they want is his X accounts. And Elon is saying they're not your X accounts. You cannot have them. They're X's X accounts. And so back off. Now here is the background on this. They say accounts on X are governed by terms of service, and we object to these accounts going bye-bye. InfoWars, they want to take band.video, they want to take War Room Show, and they want to take Real Alex Jones. And so Elon says, no, you can't have them. Sorry. Saying we don't oppose the general bankruptcy or any of those other things as a general matter, but you can't have the X accounts. Say X accounts are governed by XTOS, terms of service, and they're ours. And so what we do is we give the people who use them only an exclusive license to use it, but he doesn't own that. It's not getting transferred away. And I love this. I think that this could be a real interesting tactic. Now, like YouTube is not going to do this. So YouTube will just hand control of the account over to whoever purchases it. But YouTube could theorize it's not their account. I'm not giving you the keys to their account. It's our account. And in contrast to the services, the account holders own the content. They submit, post, or display on their services, but the content is distinct from the services. So you can have the content, but you're not getting the account. Pursuant to a successful bidder notice, the Jones IP sale motion, they say the trustee now seeks to contravene our TOS by improperly selling or transferring the X accounts. And this is great, man. Elon is coming to play. He's like, what can we do to help? His lawyers are like, make sure we keep the accounts, which neither Jones nor his bankruptcy estate own, to a third party. While X takes no position as to the sale of any of the content posted on the X accounts, X is the sole owner of the services being sold as part of the sale of Alex Jones. You can't do that. While X has granted account holders like Jones and FSS a license, like Free Speech Services, which is Jones's company, a license to use the services, such license is non-assignable, both under the terms of the TOS and applicable non-bankruptcy law. So the trustee, you don't get Jones's accounts. X is compelled to file this objection to make clear that X does not consent to the sale or transfer of any X accounts, which means the X accounts cannot be sold or transferred at this time. So don't even think about it. You are not permitted to undermine X Corp's rightful ownership of the property it licensed. Now, for the reasons described herein, X Corp respectfully submits that the X accounts may not be sold, assigned, or otherwise transferred at all, including the ones personally owned by Jones, including Jones's X account. So Jones can keep his accounts, basically. Or maybe X keeps the accounts. Jones can keep the account. Let's see. On October 15, the trustee filed the sale. They sought to sell Jones's X account. They can't do that. The successful bidder negotiated a purchase. On November 18th, this happened. Prior to the filing of this objection, X, through counsel, reached out to seek a consensual resolution of this. But the trustees council, unfortunately, while the trustees council has been working cooperatively with us, they were not able to give assurances that would have avoided us having to file this. And so we are. Now, whether this is property or not is obviously subject to a lot of analysis, but they say X owns the accounts. The accounts are part and parcel of X Corp. Courts assessing ownership have generally referred to a user's right to access the account as the property at issue. Put simply though, accounts are part of X Corp's services and their use, and they use the services. Indeed, X accounts have no value or use absent services. In addition, you can't post, react, or follow others without a license. You have to be allowed on the platform. Now, because the X accounts are governed by the terms of service, those apply, and they grant a non-assignable and non-exclusive license. So they're not the trustees to give. The use of the accounts is not relevant here, and they go through a bunch of different factors, but they're saying you can't get rid of Alex Jones's account. And so in conclusion, based on the foregoing, X respectfully requests that the motion be denied with respect to the sale of the X accounts. And so maybe real Alex Jones can stick around. We'll see. Latham and Watkins, big firm, Caroline Reckler and Christopher Harris jumping in on it. And they've got exhibits, the X account terms of service, how this all works, your license to use the service, service. They just attach all of the TOS. There it is. So it's a fun tactic. Like, you would never see YouTube do this on behalf of Alex Jones. You would never see any other platform do this on behalf of anybody. But Elon is jumping in. You're not taking away Alex Jones's accounts, not without a fight. We're here for it. Shout out to Elon. Shout out to Alex Jones. Hopefully Alex Jones gets to keep his accounts. The judge sees that that can't be transferred and he's back on X in no time.